Good morning, friends. Welcome back. Today I am going to have the ninth lecture on law and economics. This is in continuation of what the lecture spoke about contract law, and at the end of the eighth lecture, we posed a certain question that when is actually efficient to breach, or when someone can breach. So this is actually about the hunch of law and economics always brought. So I'm going to talk about the breach itself. So suppose I am an airplane builder. So you and I sign a contract. Okay. So you agree to pay me some $350,000 for the airplane. So if I agree to build you an airplane, then you value the plane at $5 lakh. So I expect building it to cost of 2.5 lakhs. So this is actually the maths which we are going to have, only simple numbers to understand the problem. So let us once again repeat it. 3.5 is our contract. Your benefit is 5. My cost is 2.5, so I am also benefiting. You are also benefiting in this sort of a contract. So lots of things could happen in between. This is what is we negotiated while we negotiated. But after the negotiation, there can be situations which changes a lot. Especially this is very interesting. At the time of COVID, things are actually changed tremendously. So anything can happen at any point of time. So price of material could go up, increasing my cost to say 7 lakh, or making it inefficient for me to build you an aircraft because we have actually a contract of 3.5 lakh, but now it is 7 lakh. So obviously for me it is actually a high cost. So making itself is an inefficient way. So cost could increase to 4 lakhs. Okay. So it is still efficient for me to build you a plane, but I no longer want to it. So for example, the cost has gone up to say 4 lakh. We will be coming to it. So I'm not interested to actually have this sort of enforcement or go for the contract. So as per the contract, so another buyer could arrive at and offer me say for 6 lakhs instead of 3.5 lakhs. Then I have all the chance to just give him the thing. So I could break my arms, making it impossible for me to build a plane. Suppose these are extremely extreme cases. So these are all reasons why I might want or need to back out of my promise. Normally these are the things which normally people back out from their promises. So there are also things that could happen that might make you want to back out. So it is not only the builder's point of view, but at the same time, if the buyer also can possibly back out, you might lose an eye and be unable to fly without depth perception. So one reason. Or you might find another seller who can build a plane more cheaply or nicer plane at the same cost, and so on. So these are actually the circumstances normally placed before by somebody who breached. So this is a kind of understanding and a contract. Therefore, as we know that a promise, breach of contract is when promise fails to keep promise. So to make a promise legally binding, there has to be some consequence when it is broken. So what should happen when a contract is breached? If penalty is too small, contract law has no bite. If penalty is too large, promises might get kept even when that becomes inefficient. So we have actually this upper limit as well as the lower limit, or upper bound and lower bound, which is actually rules the game. So can we design the law to get breach of contract when it's efficient to breach? Can you make a proposition? So this is a question. So that forms when is breach of contract efficient. So what is efficiency? As we have already figured out what is efficiency in the early lectures and all, it is quite clear that the social benefit of a breach is greater than the social cost of a breach. Then you say that socially this is efficient or efficient to breach. The first proposition. Now what happened? Social benefit of breach is less than social cost of breach, then efficient to perform. So this is what is the two proposition, very plain proposition. Social benefit of breach is greater than social cost of breach, then you can efficient to breach, then you can breach which can be treated as efficient. At the same time, the reverse, as social benefit of breach is less than social cost of breach, then efficient to perform. These are the rules which normally somebody come up. So at the same time, promises, from the perspective of promises cost to perform is greater than promises benefit from performance, then you say efficient to breach. So promises cost to perform is less than promises benefit from performance, we say efficient to perform. So you have two angles, from an individual promises point of view as well as from social point of view. So social benefit of breach, which is promises, saves cost to performing. Social cost of breach is nothing but the promisee lose benefit from promise. So if that is the case, which is very clear from individual perspective, can we design a law to get only efficient breach of contract? This is a question which somebody can raise. So promises cost to perform is greater than promises benefit from performance, then as we have already seen, that efficient to breach. So, and the other thing, so what will actually happen, that is the incentive of a promise. This is very important. So promises cost to perform should be greater and promises liability from breach, then and then only promise will breach. Similarly, promises cost to perform is less than promises liability from breach, then and then only promise will perform. So this is now making a benchmark. So a promises cost to perform is greater than promises benefit from performance implies efficient to breach. Promises cost to perform which is greater than promises liability from breach. Promiser will breach. So one makes the thing and the other thing says that that is efficient. So if we set liability from breach, which is equal to promises benefit from performance, promiser will breach exactly when it is efficient. So when a promiser breaches a contract, he should owe a penalty exactly equal to the benefit the promisee expected to receive. So this is expectation damage. As we have already said, what is an expectation damage? So in the previous lecture we have already talked about the expectation damage. So people want to have the first thing which maybe they expect is expectation damage. So if we do the example, or back to the airplane example, then we can have the plane worth 5 lakhs to you, agree to pay only 3.5 lakh. My cost of building the plane changes, then expectation damage I owe you is 1.5 lakhs. If I fail to deliver the plane, so whenever cost is less than 5 lakh, I am better off keeping my promise. Okay, so 1.5 lakh is my expectation damage, that is 3.5 lakh is the cost which we promised, but what is the expectation benefit which you have is 1.5 lakhs. So now if the cost has gone for 5 lakhs, then what would be I have to do? I have to breach and pay 1.5. So I am better off keeping my promise and it is efficient for me to build you the plane. So whenever cost is above 5 lakhs, I am better off breaking my promise and paying damage. And it's efficient for me to break my promise. That's it. So another way to think about expectation damage is eliminating an externality. That is, if I breach contract, I impose externality on you. So you expected payoff of 1.5 lakhs if I perform. So if I breach, you are 1.5 lakh worse off. If I have to pay you 1.5 lakh if I breach, then I internalize the externality. That is, whatever you lost is being now internalized by me. That loss become my loss. So now my action no longer affects your payoff in that sense. So you get the same surplus, that is 1.5 lakhs, whether or not I build the plane. So no more externality, which implies I choose efficiently when deciding whether to perform or breach. So this is now laying a foundation of what we are talking about. Now, of course, with low transaction cost, we could always negotiate around an inefficient rule. This is what is normally cost try to say. People try to inculcate this idea as Gaussian idea. That is, a plane worth of 5 lakhs. Do you agree to price 3.5 lakhs? My cost of building the plane changes. No penalty. If cost rises 4 lakhs, I would want to breach, but we could renegotiate a different price. So penalty for breach is 1 million, suppose, a huge penalty. If cost rises to 7 lakh, I would have to perform, but we could negotiate a buyout price. So that is next possibility. So only expectation damage guarantee efficient breach or performance even without renegotiation. So this is why expectation damage is a very interesting case which people try to talk about. So another reason the remedy for breach matters is investment in performance. Now, not only the expectation damage, expectation benefit, etc. There are other things people actually invest in performance. Okay? Many things promiser can do to reduce likelihood they will have to breach a contract. If promiser agree to build a house, he can buy material ahead of time and store them in a warehouse, spend more time lobbying or bribing local government to ensure he can get required permits, pay his assistant well, so he is less likely to quit. So many things. So some of these things may be hard to observe or verify, so impossible to build them into the contract itself. All these things cannot be actually written in the contract, because this is why we call it as incomplete contract kind of thing. So expectation damage and only expectation damage will lead to efficient level of these investment. If promiser internalize these costs or the cost of breach, then he receives the full benefit of these investments along with paying their full cost. So to minimize private costs, he chooses efficient level in that sense. So if penalty for breach is less than expectation damage, breach still imposes negative externality. So investment in performance imposes positive externality on promisee. So promiser will invest less than efficient amount in that context. So this is what is actually about the investment in performance as well as the expectation damages. Now let us talk about other costs also, the reliance cost, which I will just flashed on. You expect an airplane to arrive in spring. So if I am expecting something, then I may be having some reliance investment. For example, signing up for flying lessons, building yourself a hangar, buy a helmet and goggle for your flight. These are called reliance investment. Reliance investment which depends on performance. That is, reliance increases the value of performance to promising. So So Reliance increases the social cost of breach also. Another aim of contract law is to secure optimal level of reliance. That is, when is reliance efficient? No, reliance means I cannot actually have all kinds of cost built into the thing, and then if there is a breach, ask for it. So this is also going to have a kind of discussion about the efficient level of reliance, or the minimum reliance, or the maximum reliance investment, etc. So when social benefit of reliance is greater than social cost of reliance, or social benefit, increased benefit through promisee, that is the value of airplane plus hangar minus value of airplane without hangar, is what is called the social benefit, okay, which is increased after the reliance investment. So value is only realized if the promise is performed. So what is the social cost? The direct cost borne by the promisee. So cost occurs whether or not promise is performed. So these costs are the cost which is in economics really called the sunk cost. Reliance is efficient whenever increase in value of performance times probability of performance, which should be greater than cost of investment. So this is what is called reliance is efficient. So reliance and damage example: you are buying the airplane from me. Price is 3.5 to be paid on delivery. So airplane alone gives you benefit of 5 lakhs. Building a hangar cost is $75,000. Airplane with a hangar gives you a benefit of 6 lakh. Now without hangar, expectation damage is 1.5 lakhs. If you build a hangar and I fail to deliver a plane, do I owe 1.5 lakh value of original promise, or 2.5 lakhs value of the performance after the investment, or 2.25 lakhs value of original promise plus reimbursement you for investment you made, or some other amount? These are the questions normally people ask. So many options to get efficient breach. So the only way to guarantee efficient breach is if damage include the added benefit from a reliance. We will come to the questions and the answer. So once you have made investment, you anticipate benefit of 2.5 lakhs from the performance. So if damages are anything less than that, I'll breach too often. If damage exclude the added benefit, then I am back to imposing an externality when I choose to breach the contract. So what happens to the incentive for reliance investment if damage will increase to include this added benefit? So if expectation damage include benefit from reliance, if you don't build hangar, your payoff will be 1.5 lakhs if I deliver the plane, that is 5 lakhs minus 3.5 lakhs, 1.5 lakhs if I breach and pay expectation damage. So if you build a hangar, your payoff will be 1.75 lakhs if I deliver the plane, that is 6 lakhs minus 3.5 lakhs minus 75,000. So if 1.75 I breach and pay, higher expectation damage. So if expectation damage include the increased value of performance due to reliance investment is this amount. So you will invest whenever increase in benefit which is greater than cost. So in this case you will invest because 1 lakh is greater than 75,000, or go for it. If expectation damage include increased value of performance, you will invest for sure. Now the question is this efficient? Reliance is efficient if increase in benefit times probability of performance, which should be greater than the cost. That is 1 lakh time probability of performance is greater than 75,000. Then only you will do it. So only efficient if probability of performance is 3 by 4. Okay, that is, otherwise you won't. If probability of performance is less than 3 by 4, reliance is inefficient. but happens anyway. So, which is we call the over-reliance problem. So in that sense, what we are trying to understand, we understand reliance cost, reliance benefit. At the same time also we learn that whether we are having an efficient reliance investment or an over-reliance or an under-reliance. We will also come to that point later. So 3 question immediately derives out of this thing, that is, let's P be probability of a breach. That is 3 questions. What is the efficient level of reliance? What will promise do if expectation damage include anticipated benefit from reliance? And what will promise do if expectation damage exclude anticipated benefit from reliance? So a calculation we had made, but that calculation is the result is this one, that is x is equal to $90,000, that times 1 minus p to the power. So the other one 90,000, the last one excluded anticipated benefit cases 90,000 times. So this is the calculation which we had. Alright, so now let us talk about the over-reliance problem. Okay, so if reliance investment increase, the damage you will receive in the event of breach, you will over-rely. So you will rely if increase in benefit times probability of performance plus increase in damage times probability of breach is greater than cost of investment, then efficient to rely. So efficient to rely, if increase in benefit time probability of performance is going to be greater than cost of investment. So if damage and increase when you make reliance investment, we are sure to get over reliance. So this is the problem, your investment imposes an externality. So this is what is about the over reliance and other things. So reliance and breach, so just showed if damages include added benefit from reliance, promisee will invest more than efficient amount. But if damages exclude added benefit, then promiser's liability is less than promisee's benefit from performance, which means promiser will breach more often than efficient, and promiser will under invest in performance. So this is what is maybe similar to the paradox of compensation. That is, single price damage outsets multiple incentives in that sense. So imposes to set them all efficiently. So what do we do? So in the Couturier text, include only efficient reliance. This is the kind of proposition they made. That is, perfect expectation damage restore promise to level of well-being he would have gotten from performance if he had relied the efficient amount. So promisee rewarded for efficient reliance, not for over reliance. So this is what is actually the kind of results normally people try to talk about, or they try to discuss. Now in the actual code include only foreseeable reliance, not even reliance. That is, if promiser could reasonably expect promisee to rely that much. So this is what is called the foreseeable reliance. Let's talk about an example, which is a court case of England, Hadley versus Baxendale's example. So 1850s England, Hadley ran flour mill, crankshaft broke. This is an incident. So Baxendale's firm hired to transport broken shaft for repair. So Hadley is actually the mill owner. The crankshaft has broken. Baxendale's firm is actually the transport firm, which is supposed to transport the crankshaft. Baxendale shipped by boat instead of train, making it a week late. So Hadley sued for week's lost profit. The shipper assumed that Hadley, like most miller, kept a spare shaft. Hadley did not inform him of special urgency in getting the shaft repaired. So this is the question. So court listed several circumstances where broken shaft would not force mill to shut up, and ruled lost profit not foreseeable. and Baxendale didn't have to pay. This is the court order. Before you can award damage for wage paid and lost sales while the mill was idle, you must first find that at the time they entered into the contract to ship the crankshaft, the shipping company contemplated that the mill owner would suffer those idleness damage as a result of late delivery. So, toward damage for lost sales, Hadley should have to prove that Baxendale could have predicted those losses. So, this is the problem. So, why didn't Hadley and Baxendale just specify in the original contract what happens in the case of delay? This is a question which is a very important one, which we keep asking beginning, or we start asking hinted in the very beginning. That is, what rules should apply in circumstances that aren't addressed in a contract. This leads us to examine a new topic which is called a default. Now, we had an expectation damage kind of thing, reliance problem, over-reliance, all this is actually about the, now things are not being written in their contract. What is going to happen, or which rule you are going to upload. So in that kind of question, the immediate answer is that a default rule. What is a default rule? Gaps, risk or circumstances that are specifically addressed in a contract. Default rule, that rule applied by court to fill the gaps. That is, writing something into a contract with a leaving a gap. Allocating a risk ex ante before it becomes a loss. So this is what is called this kind of a gap versus allocating a loss ex post. Okay, so you have an ex ante risk as well as an ex post loss, right? That is, only have to deal with it if the loss occurs. So this is what is called the default rules point. Now suppose if the default rule applies, then the Hadley and Baxendale's case would have tended differently. That is, Overreliance used the rule parties would have wanted if they had chosen to negotiate over this issue. This will be whatever rule is efficient. So fifth purpose of the contract law is to minimize transaction cost of negotiating contract by supplying efficient default. So we have other issues like along with that, now we have an issue of not only efficient breach, but also we have an efficient default rule. So do this by imputing the term the parties would have chosen if they had addressed this contingency. Now what is the default rule? Example, probability 1/2, the cost of construction will increase to $2,000. Construction company can hedge this risk for $400. Family can't do anything about it. Price goes up, who pays for it? Construction company is efficient bearer of the risk, so efficient contract would allocate the risk to a construction company. Should prices be adjusted to compensate? So Overreliance says, set the default rule that's efficient in the majority of cases. Most contract can leave this gap, save on transaction costs. In case where this rule is inefficient, parties can contract around it. So this is what is the results which we can see from the textbook. Default rule, a different view. So let us have a very different view other than this particular. For example, Ian Ayers and Robert Curtin state filling gaps in incomplete contract and economic theory of default rule. So this is a very interesting observation. So sometimes better to make default rule something the parties would not have wanted, to give incentive to address an issue rather than leave the gap, or to give one party incentive to disclose the information, which we call the penalty default. Alright, so penalty default, if we apply penalty default instead of the default rule, Hadley versus Baxendale case turns completely different. That is, Baxendale shipper is only one who can influence when crankshaft is delivered. So he is in fact the efficient bearer of the risk. If a default rule held Baxendale liable, Hartley has no need to tell him the shipment's urgency. So Hartley might hide this information, which is inefficient also. So Ayers and Gardner's result, that the ruling in Hadley was a good one, not because it was efficient, but because it was inefficient. Okay? But in a way that created incentive for disclosing information. So in that sense, this is what is called the deficient disclosure. And disclosing information comes into picture now. Penalty default example, suppose 80% of the millers are low damage, suffers $100 in loss from delay. Now 20% of the millers are high damage, suffers $200 in loss from delay. Now shipper liable for actual damage. What happens? Average miller would suffer $120 in loss. So shipper makes efficient investment for average time, but not efficient for either time. So shipper liable for foreseeable damage. Shipper makes efficient investment for low damage miller. High damage miller have strong incentive to negotiate around default. So real estate brokers and earns money. Broker know more about real estate law. Default rule that seller keeps earnest money, encourages brokers to bring it up if it is efficient to change this. So these are the examples normally one can look into. Then the other problem, court will impute missing price of good but not quantity. That is, force party to explicitly contract on quantity rather than leave it for court to decide. So when to use penalty default, then that part of a problem need to be addressed now. Look at why the parties left a gap in contract, because of transaction cost, which leads to efficient rule. For strategic reason, penalty default may be more efficient. Similar logic in Supreme Court dissent by Justice Scalia pointed out. So Congress passed a RICO law without institute a statute of limitation. So majority decided on 4 years what they thought legislature would have chosen. Scalia proposed no statute of limitation, unmoved by the fear that this might prove repugnant to the genius of our law, that is, the genuineness of the law maybe gets scuttled because of this law. So indeed it might even prompt Congress to enact a limitation period that it believes appropriate, a judgment far more within its competence than ours. With this, I would like to end the lecture, and we will see the further developments of contract in the coming lecture. Thank you once again for listening me. Thank you very much.